Hello, everyone, and this is about Regulation 30 of the listing regulations. Once again, as this regulation began getting into implementation mode from either the 15th or the 14th of July, depending on which way you interpret, some very interesting disclosures came to the notice. While there were questions coming from clients all over of the kind of show cause notices, kind of regulatory actions, etc. But a very interesting disclosure, which I'm sure many of you might have also heard about, is a disclosure made by some listed entity of a penalty of rupees 1,000 imposed by the local authority of some particular town or village somewhere. I'm sure that municipality must be quite agile, quite Swachh Bharat inclined municipalities, of for not keeping a dustbin outside one of the outlets owned by the company, owned or hired or run by the company. दुकान के बाहर या फूड आउटलेट के बाहर डस्टबिन नहीं था बोल के 1,000 रुपए का फाइन या पेनल्टी कंपनी पे इम्पोज किया. And this notice has been gloriously uploaded by the listed entity on the stock exchange. I'm sure the compliance officer would have exactly done what any compliance officer would do, which is to take a literal view of the provisions of Regulation 30, read clause by clause. If you did the same thing, I'm sure you would come to the very same conclusion which this compliance officer would have done. And therefore, I'm absolutely inclined to agree with what the compliance officer might have done. Have a look at the provisions of Regulation 30. 30/2 says events specified in para A of part A of Schedule 3 are deemed to be material. Therefore, don't apply mind here. यहाँ दिमाग लगाने की जरूरत नहीं है. मैंने जो बोल दिया वो deemed material है. And when it comes to part A, para A of part A, there are 21 in terms of number. But if we add up the capitalized items in between, there probably will be 22 items in part A of para A of Schedule 3, which are deemed material where there's no scope for application of mind, irrespective of size or magnitude of the event information. Just go and disclose. Then comes para B, where also the regulations have now laid more numerical thresholds. The thresholds have been taken off from subjectivity. The thresholds are made objective. But that's not our topic for discussion today. We're still focusing on part A, para III.A.A. And we're specifically looking at item number 20, which is where this imposition of fine of rupees 1,000 by the local authority for not keeping a dustbin would potentially fall. Now look at the language of item number 20. Action or actions taken or orders passed by a regulatory, statutory, enforcement or judicial authority. Enforcement authority or judicial body. We're talking 4 types of bodies. Regulatory body. One could probably say, well, Reserve Bank of India, SEBI, IRDA, these are regulators, the sectoral regulators. Statutory body, any body which is constituted under a statute. Kolkata Municipal Corporation, for example, is a body under a statute. It comes under the local Kolkata Municipal Corporation Act. Likewise, I'm sure there are local authorities act. The panchayats are also probably bodies constituted under some law. Enforcement authority, for example, local police will be enforcement authority. Enforcement directorate, as the name implies, enforcement authority. Judicial body, I don't think we need to get into discussion as of now. So we're talking about statutory body, action taken or order passed. And if you run through the list, while the list is comprehensive, it has sort of very serious things such as suspension, settlement, debarment, disqualification, closure of operations, sanctions, warning, caution, etc. But it's talking about imposition of fine or penalty. Now, fine again, fine is a fine word. As the name, fine is quite fine because fine is typically criminal prosecution and fines are imposed only through a criminal prosecution process. But the word doesn't limit with fine. It says fine or penalty. Penalties are typically imposed by administrative authorities. That's what called internal adjudication mechanism. A penalty can be imposed even by a traffic police officer. If you jump the signal, the traffic police gives you a pavati, gives you a receipt, which is a penalty. Composition of an offense by imposition of a penalty. So that's a penalty. And the local municipality in this case, local authority in this case, would have imposed a penalty of rupees 1,000 for not keeping dustbin. So technically, strictly speaking, this item did fall under 20, and that subclause B. If you were to read it further, because it talks about along with following details pertaining to action, and then goes to say name of authority, nature of details, details of action, date of receipt of direction, details of violation or contravention, impact on financial operation or other activities. One could have probably read this clause to probably imply that the actions in question referred to in item number 20 are those which might have an impact on a financial impact or impacting the operation or impacting other activities of the listed entity. That could probably be one potential interpretation. But one could also interpret and say that if there is an impact, I'll disclose the impact. If the impact is not negligible, the impact is not there at all, I'll probably make that disclose. Say the impact is negligible, impact is not there at all. That might also be one possible line of interpretation. So literally speaking, even a fine of 1,000 rupees for not keeping a dustbin probably could be more trivial examples you could think of. So trivial fines are now coming for disclosure under Regulation 30. Are we doing a justice to the requirement of disclosure? The whole intent of Regulation 30 was to have meaningful information placed in the domain of shareholders, stakeholders, public at large. If you talk about fines of 1,000 rupees or peltry amounts for a large entity with multiple locations, thousands of branches, thousands of operational units, this kinds of fines or penalties are imposed, I would guess, on a daily basis. One of our clients, which is actually banks, told us that we receive about 10 show cause notices a week. So this kind of trivial negligence, nominalities of small amounts of 1,000 rupees or less or similar. I mean, the question is not a question of amount. I mean, if 1,000 rupees is trivial, we'll probably say, what about 1 lakh? Where do we draw a line? The issue basically is that are we therefore now deeming any imposition of a fine or penalty to be material, irrespective of magnitude, and dumping the disclosure on exchanges? What damage are we doing? Are we doing a meaningful service to the need for investor information? I think that is unarguable. No one probably would contend that a small penalty of 1,000 rupees would do a great lot of investor service. But look at the cost on the companies. From the operating unit, somebody would have applied mine that I need to disclose it to my senior. That senior would have taken to next level. The next level would have taken to compliance officer. The compliance officer would have huddled into a meeting to take a decision on what to do with this grave fine of 1,000 rupees. Eventually, the compliance officer must have gone and disclosed it. The once it's out on exchanges, probably thousands of people would have read. And once again, brain cells of thousands of people would have been occupied on this information, which by no stretch of imagination could actually be a relevant or meaningful information. So is it possible to draw a line? I mean, I would say, frankly and fairly, this is an area where SEBI actually has to come up and draw a line that this 1,000 rupees, 10,000 rupees, 5,000 rupees is not something that's actually making a difference. Therefore, draw a line either in terms of magnitude or say, let companies apply their what do you call subjectivity and take a call on whether it's actually impacting the operations or other activities. So the Roman 5 of the requisite disclosure, which is a part of item number 20, that might actually be read to mean that only where there is an impact either on finances or on operations or activities of listed entity, that's only when a disclosure is warranted, because the rest of the items actually seem to be suggesting that suspension, for example, stops the operation. Imposition of fine or penalty might be of such a level which might impact the finances. Settlement proceeding once again might mean a significant financial impact. Debarment impacts operations once again. Disqualification, closure of operations, sanctions imposed, warnings or caution. Each of these are things which impact operations. Whereas a paltry amount of penalty is neither here nor there, is just a part of business as usual. And therefore, are we meaning to require disclosure of these trivialities? Look at the compliance cost. Also look at the fact that if trivialities are becoming a part of disclosures by companies, materialities will get buried under trivialities. That's always the rule. As weeds overtake shoots, as grass overtakes meaningful crops, weeds are always more powerful than meaningful crops. Likewise, triviality will always overtake materiality. And people will continue to apply literal interpretation to make this immaterial disclosure. The whole purpose of Regulation 30 would be lost if this is the view that continues to be taken by compliance. Compliance officers are not to be blamed. They're definitely not to be blamed. And definitely, I don't think anyone with a literal reading of Regulation 30 would have taken a different view. If one was to come to my, let's say, advice, would I actually dare to take a different view in view of the very clear language of Regulation 30? I probably wouldn't. And therefore, I would still stress that it's SEBI or the exchanges which have to take a firm view and take a meaningful silver line above which only the disclosures are required for regulatory actions. But otherwise, if we keep dumping trivial information, I think the very purpose of this regulation would be lost. We will also intend to discuss what exactly is the relevance of show cause notices. That's another important item in Regulation 20. Regulation 30, item number 20. We are meaning to come up with an article on that. And we hope to be discussing more of Regulation 30 intricacies. And that's a very, very important change for listed entities. Look forward to more of our write-ups and videos. Maybe also think of interacting as a part of a workshop as well. But in the meantime, thank you very much. Do let me know in case you have any particular thoughts on this. Thank you very much.